Okay, folks, what we have here is the audio of a court case that some of you will have heard. I'll just give you a quick précis of what the issue is. So this is a Victorian woman who was charged with being too far from home during the COVID pandemic, and she was issued a fine and then taken to court. Now, what I've been told is that the state took her to court to prosecute her for this fine. Okay, that's what I've been told. So everything I'm going to say is based on the fact that she didn't elect to have this fine taken to court. Instead, the state took her to court. Because why that's important is that if she'd elected to have this fine heard in a court, then she would have contracted with the court, and I think everything she does thereafter wouldn't have worked. The end result of this is that she has a success and no fine is imposed, or upheld, I should say, by the court, but she only just makes it. I know, and what we're looking at is someone else's interpretation of this audio. So I haven't done the wording that you'll see on the screen. I'm going to stop and reference that. I believe whoever's put this wording up has got quite a lot of it incorrect, and I will pause the video as we go through and explain step by step what I believe is happening. Of course, you have to make up your own mind. But the starting point is that the state has sent her a notice to attend the court, and she hasn't requested that a court hear this matter. Okay, so let's just play it, and I'll stop and pause it as we get to something I need to discuss.
Yes, can you hear me?
Yes, I can hear you, so that's fine.
Yep, I'm also on camera.
Today?
Yes, I am.
Oh, sorry. Oh, yeah, thank you. I'll just read the charge out quickly for you. So it's at Melbourne on the 13th of September 2020. Did fail to comply with the direction given to that person. That direction being to stay at home unless for essential shopping, work, exercise or caregiving purposes, having been given by a person exercising the power granted by the Chief Health Officer under Section 199 of the Public Health and Wellbeing Act. So in relation to that charge today, are you intending to plead guilty or not guilty?
So, Your Honour, I am the living woman.
Yes.
I'm the beneficiary of the trust. I do not consent to contract or joinder, and I waive the benefits on offer.
Okay, so I'll take that statement to mean that you're intending to plead not guilty today, so thank you for that. I think.
Okay, so what it says on the screen there is she's made no offer to plead anything, which is correct, let alone not guilty. She's saying she's not going to accept the court's offer to adjudicate the matter at all, yet they speak for her dishonestly, confirming her consent to plead not guilty. Okay, I believe this is completely incorrect, and it was at this point in the case that she had the opportunity to end this right then and there. But as you'll see, this goes on for quite some time. So what is written on the screen there, I believe, is completely wrong. What's happened is that she has told them she doesn't wish to contract with them. The magistrate has then made a claim that her intention is to plead not guilty. And at this point, she has consented to plead not guilty by remaining silent. At this point, what she should have done is rebut his claim that she was intending to plead not guilty. And she could have said many things, but just saying, no, that's not correct. My intention is to not enter a plea one way or the other. My intention is to make it clear to you that I don't consent to contract with you, and I do not consent to you administering my estate. And if she'd said that right then and there, he had one more chance to trick her, and if she'd repeated it again, a third time, it's all over right then and there. You'll see this goes on for quite a while though, because at this point, because she didn't rebut his claim that she intended to plead not guilty, matters proceed on the basis that she has in fact consented to plead not guilty because she remained silent.
Mr. Prosecutor, in this circumstance, yes. I haven't had any prior correspondence. I can't see that there's been any case commenting in the matter, but certainly no objection to the matter going through any contest. Yes, thank you. I think it's suitable. I'll get a date, case contest mention date. So, so the next, I'll give you a next date now. This will be the contest mention date, okay?
So again, on the screen, it says they keep saying okay to get her consent, but she refuses to acknowledge that it's okay. Still, she refuses to consent to a contest. This is incorrect. By remaining silent, she is consenting. That's the key. She is remaining silent, and whilst she remains silent to everything they suggest to her, she is giving tacit consent. So at this point, she has consented to them hearing the case and pleading not guilty on the basis that she has remained silent when he said to her, I'll take that you mean to plead not guilty.
So there's various steps that the matter has to go through before it gets to a contested hearing. So I understand that's what you've been looking for eventually anyway, would be a contested hearing or some chance to address the court in relation to the charge. Today's only a mention court, so we're sort of triaging matters into basically matters that are going to be pleas of guilty or pleas of not guilty. So not guilty pleas need to go down a different pathway. So if you just hold on there for a second, we'll get a new court date.
So, Your Honour, are you administering my trust without my consent?
Right. Now she has rebutted his claim that she intends to plead not guilty. And now he's floundering a bit, you'll see. So finally she has saved it, but she was heading down the wrong path here. She was going to lose this until she said this again. Because until she spoke, she was agreed to have consented to all the things that they had stated. And it says on the screen, she now makes it clear she's consenting to nothing and asks if they're making decisions on her behalf without her consent. Well, she specifically says, are you administering my estate without my consent? Or she says trust, but she's making it clear that she hasn't consented to contract now that she says this. But she was in jeopardy. I want to suggest she was in jeopardy the entire time the magistrate was putting things to her and she remained silent. Because they presume you are consenting while you remain silent.
No, there's no administration of any trust at the moment.
Right, so he says there's no administration of any trust at the moment, and that's the key. And that is also evidence that there is a trust. If there's no trust, he'd say, I don't know what you're talking about, what trust? He doesn't say that. He says there's no administration of any trust at the moment. But she says trust, and his response isn't, what trust? What are you talking about, crazy woman? He says no one is administering a trust at this moment, which means they are intending to, and they possibly already have been. Okay? You've got to listen carefully. And now, the blurb here finally gets it right. They're trying to get her agreement by her silence, but she won't have it. Now they recognise that silence is consent, but the problem is they didn't recognise it, whoever put this blurb to the video, they didn't recognise that her silence was her consent when he suggested to her that he would interpret what she was saying as her desire to plead not guilty. So they're aware that silence is consent, yet they've missed it when he said to her, I'll take that you intend to plead not guilty.
We're just dealing with the matter under the Criminal Procedure Act, okay, so that's 2009, an act in force in Victoria, and the next step will be a mention date under the Criminal Procedure Act, under Section 55 of that Act. So if you take it over Section 55 of the Criminal Procedure Act, that'll be the next court date in relation to that. And that'll set out the process of what's occurring.
I do not consent to contract or joinder, and I waive the benefits on offer.
Right. Now she's said it a third time. And now they can't proceed. Okay? So she said for the third time she doesn't consent to contract. And so now they're in trouble.
Thank you, Miss. Your matter now is booked in for the next court steps to occur. The next court date is the 7th of December. Okay, so that'll be a contest mention back online in the Melbourne Magistrates Court. Okay, so that might take between 15 minutes and half an hour, depending on what's discussed on that day. But that mention date will give you a better chance to discuss your matter further. Okay.
Okay. I mean, I don't want to be harsh on her. She's doing really well. But she's missed another opportunity here. They talk about a mention date. All right? Again, they say, you'll be back here for a mention. She didn't rebut that. She didn't say anything except she gave tacit consent to it. So she gave tacit consent to another hearing. All right? She could have ended it right then and there. She could have said, she could have said other things. There's no need to waste my valuable time. There's no contract and the matter is concluded. And I instruct you to conclude the matter now. That's all she needed to do. And she wouldn't have had to come back. As you'll see, she comes back. It's by video link, but because it was COVID and she was probably at home. But she has to come back for another very brief hearing, which they shut down before it even starts. So she's won. But again, that was an offer for her to come back on whatever date he said, come back and do it another time. She could have just said, I don't consent to having the matter put over to whatever sort of hearing he said it was. And it would have been all done then. But she's done very well.
And the submissions you wish to make. Okay, so thank you for your time today in court, and you're now excused.
Thank you for your time, Your Honour.
7th of September.
And so this is now the second hearing.
Thank you. We'll just confirm. You're on the line there. You can see and hear us?
Yes, can you hear me?
Yes, I can. Thank you.
Your Honour, it's an application to withdraw this matter.
All right, thank you. On the prosecution application, they have the charge withdrawn. Charge is now struck out. Thank you. The charge has now been struck out. You may be excused.
Thank you. Thank you, Your Honour.
Thank you.
And so there you have it. They just ran like the clappers. But they chose to strike it out. See, because she didn't stop them bringing her back for a second hearing, it now gives the impression that the prosecution has withdrawn their case for whatever reason. Mercy, who knows what. That's not the case. They weren't able to hear the case, but by her not killing it then and there and saying, no, we won't be coming back on the 5th, I don't consent, they can now present it, knowing this recording was probably being made because it was done by video link and knowing it's all recorded. They can now put a spin on it that, well, to the untrained ear, it sounds like, well, for whatever reason, they just decided to drop the case. They probably felt sorry for you or whatever else. But if she had said at the end of the first hearing, I don't consent to this matter being heard by this court, I don't consent to you administering my estate, and I don't consent to have this matter put over to another date, the matter can be finalised now, the matter will be finalised now. If you choose to elect to bring me back in 2 weeks' time, my fee for my time, and then you just name a price, $20,000, $50,000. So if there's another hearing, I will come and you'll owe me $50,000. And if they then dropped it, if you'd said something like that and they dropped it, it'd be pretty clear to everyone what was going on. But the way it's done, if you showed this to what we'll call a normie, they would just shrug their shoulders and say, that doesn't prove anything. Okay, that's that. That's my analysis of what's going on here. And I think there's a couple of errors in the narrative that's been whoever put this together, I think they made a couple of errors in the narrative, because she has given tacit consent to a number of things, such as having a second hearing, such as pleading not guilty. She corrected the tacit consent to pleading not guilty when she subsequently said, again, a second time, she doesn't consent to contract with them. But until she said that, the presumption was she did consent. So you can rebut this. You can rebut the presumption. You don't have to rebut it right in the moment. It's better if you do, but you can rebut it later. But she managed to do so in sufficient time that they had to just drop the case to save face. And this is what I'm talking about when I say you're not going to get it in an open admission ever. What they've done here, the pantomime of the second case, is to give the impression to anyone who doesn't know the details of what's really going on that she was just very lucky that they decided to let her off. Anyway, I'll leave that with you.